Hello, Canada. This is Alex Monahan here, Foundations Party, ineligible. I know it's been a year since my last confession. I apologize about that. Just a lot's been going on in my life and just trying to sort a few things out. And as promised, I'm doing a very light review of the Criminal Code. It's a very good document for the most part. There's just a few things that I saw that I thought could be maybe reworded and just nipped and tucked a little bit. But I also want to tell you guys that I myself am not an attorney. I am not a student of law of any kind. I am just a man with an opinion. I have read it. I'd like to share my opinion with you, and in no way, shape, or form am I intending to try and coach anybody to do something that they shouldn't do. So, I encourage everybody to read this for themselves and make their own opinion. So, let us begin. Under the Criminal Code, paragraph 5 is stated as sexual intercourse, and for the purposes of this act, sexual intercourse is complete on penetration to even the slightest degree, notwithstanding that seed is emitted. This in itself isn't a problem. I'm just feeling that it's missing something. I personally believe that we need to add after penetration or forced to penetrate, even in the slightest degree, notwithstanding seed. I think that would be more fair. I think that would be more encompassing because, again, we wouldn't want to take the rights and freedoms away from women and equal opportunity even to commit crimes. Under sexual offenses, paragraph 150.1, subsection 1, is the next one I want to start reading to you. And it's quite the doozy, so if you'll bear with me. So 150.1, subsection 1, subject to subsection 2 to 2.2, when an accused is charged with an offense under section 151 or 152, or subsection 153.1, 163 or 173.2, or is charged with an offense under subsection 271, 272, or 273 in respects of a complaint or complainant under the age of 16 years, it is not an offense that the complainant consented to the activity that forms the subject matter for the charge. Exceptions. Complainant age 12 to 13. Subsection 2. When an accused is charged with an offense under section 151 or 152, subsection 73.2 or section 271, in respects to the complainant who is 12 years of age or more, but under the age of 14 years, it is a defense that the complainant consented to the activity that forms the subject matter of the charge. If the accused, and this is perjury information, it's the guidelines that it's under, is A, is less than 2 years older than the complainant, and B, is not in a position of trust or authority towards the complainant, and is not a person with whom the complainant is in a relationship of dependence, and is not in a relationship with the complainant that is exploitive of the complainant. Exceptions. Complainant 14 to 15. 2.1. If the accused is charged with an offense under section 51 and 52, or 52, or 52, I guess, subsection 73, 2, or section 271, is expressed of the complainant who is 14 years of age or more but under the age of 16. It is a defense that the complainant consented to the activities from what the subject matter charge is accused. A is less than 5 years older than the complainant, and B is not in a position of trust authority towards the person, like the section above it for B. And I just wanted on that part was it's very wordy. It's kind of confusing. The subsection 1 kind of argues with sections 2 and 2.1. So what I was, my understanding of what this says, and maybe a better way of wording it, would be anybody who has sexual intercourse or relations with somebody who's 11 years of age or younger, it is not a defense that the person in question or the complainant gave consent. Oxford comma. For it is not a defense for someone to have sexual intercourse or relations with someone of 12 to 13 years of age, unless that person is no more than 2 years older than them. And of course, not in a position of power, authority, mentorship, all that other kind of stuff. And, add in all the extra pertinent information for like 173.2 and 2.1, or, Oxford comma for 2.1. It is not a defense to say that somebody within the ages of 14 and 15 gave you consent, unless you are no more than 5 years older than the complainant. And maybe at that point we could add in or no more than 2 years younger than the complainant. We can even add in like one may need parental approval if you're outside of those limits. But then again, that in itself is kind of a push, and may be more pertinent for the next section, where anyone that's age 16, because you'd put a comma, and then anyone who's 16 years of age or 17 years of age who enters into a relationship with anybody would either need parental consent to consent to dating somebody or being in a sexual relationship with somebody who's 18 years or older, depending on up to maybe 5 years to a point, or they may need their parent to give them kind of consent to maybe date somebody younger than them up to maybe 2 or 3 years, depending on what a court might be comfortable with. And I think that would be a little bit more clear. I think we could arguably get a much better result if we kind of word it that way. It'd be easier to understand, and then we can add in all the extra pertinent information and cite all of the 173 subsection 2, 271, 17, and all that other kind of good stuff that it's kind of going to need. So that was just kind of my thoughts on that. The next part is corrupt morals, paragraph 163.1. It reads, everyone commits an offense who A. makes, prints, publishes, distributes, circulates or has in the possession for the purpose of production, distribution, or circulation of any obscene written material, pictures, models, phonographs, records, or other things, whatever. Or B, makes, prints, publishes, distributes, sells, or has in his possession for the purposes of publishing, distribution, or circulation a criminal comic. I personally think this needs to be repealed. I think it's, first of all, kind of redundant. We have enough legislation that protects against child pornography. We have enough legislation that protects against photos that may have been given as a gift, or rights to all those sorts of things. This legislation itself may only serve to reduce a person's opportunity to be creative, and we have legislation already for appropriate packaging for things that might be seen as mature subject matter and may contain like coarse language and all those other kinds of things. So to me, this one's a hard one to kind of like, well, I don't see what it's really for, because it's a little redundant in my opinion. We already have a lot of information to take care of a lot of these other things, but this one also really limits anybody else's creativity to do something that somebody else might enjoy, but again, somebody else might find it offensive. But that's kind of hearsay, and that's why we put warning labels on it. Because this may be offensive. You may not want to buy this. This will have these kinds of things in it, and we've already kind of got systems for that. It's got to go, if you ask me. The next one, duties of a person to provide necessities. 215.1. Everyone is under a legal duty, A, as a parent, foster parent, guardian, or head of the family, to provide necessities for life of a child under the age of 16 years. B, to provide necessities of life to the spouse or common law partner. And C, to provide necessities of life to a person under his charge if that person is unable, by reason of detention, age, illness, mental disorder, or other cause, to withdraw himself from that charge, and is unable to provide himself with necessities of life. This one to me is a little light on words, because it doesn't explain enough, like how does that apply to a divorce settlement? Because in my own opinion, paying alimony in its own right is another form of slavery, and we need to like sit down and have a talk about how should we actually do that, because saying a lady gets nothing for being married isn't completely fair, but then again, saying that a lady can take everything from a guy because she was married isn't completely fair either. So we have to find the middle ground on what works for everybody. And then again, I'm not sure if they define completely things like head of family. So it's like, say if I'm the head of my family, a family member walks out, like a brother or a cousin, on their spouse, am I responsible for their kids? Does it mean that? It could possibly mean that. Even though, yeah, there just needs to be a little bit more information on what this entails to, so that everybody can be successful. Because it's a little light worded for me, because it could be misunderstood. Now, the next section I wanted to talk about is assault. I didn't write anything down because that's a big section and it would take me forever to kind of review it. Instead, I'm going to just kind of talk about what I think about it, because under the code, an assault is any force applied intentionally or unintentionally. And so if you get arrested and you get sent to a judge, regardless of how you assaulted somebody, the judges are kind of ignorant to that, and they don't really know, and they treat you the same way they would have treated anybody that like attacked you with a baseball bat or something. And in my opinion, that's a problem. So I think we need to have more defined types of assault. Like if we had like unwanted contact and maybe the levels of it, and then maybe horseplay, and then the levels of it, and then maybe battery, and then the levels of it, and then maybe attempted murder and the levels of it, and any other things that I might have missed that might fit into that, with either sexual connotations or non, you know, maybe biological weapons, all those other sort of things. Ooh, sorry, my foot's asleep. And I think that would be a little bit more successful, because then we could even like add in other suggestions for a judge to help them decide on how to deal with or punish somebody, because maybe unwanted contact could be like you take your finger, you poke somebody in the face with it, they get upset, they charge you, and instead of giving you like jail time or something, or treating you very poorly that way, maybe giving you a punishment that would support the crime. Because I heard about some judges doing some things like, if you took a cab ride, didn't pay for it, and you were taken to court, you were then expected to walk the distance in the cab that had driven you. And I thought that was a kind of an interesting punishment to discourage you from doing it again. I was thinking that we could use those sort of ideas to kind of give judges something to work with, and how to punish people and try to discourage somebody from doing it again without being overly forceful and maybe abusive. And then again, maybe they could get like a couple hours worth of community service or something for like just bothering somebody. At the very most, that might be okay. The next section, I think I'm misunderstanding this one, but I'll read it and then I'll explain what I'm thinking. So it's obligation. Oh no, it's obtaining sexual services for consideration. 286.1, subsection 1, everyone who in any place obtains for consideration or communicates with anyone for the purpose of obtaining for consideration the sexual service of a person is guilty of a minimum punishment of 1, in the case where the offense is committed in a public place or in any place open to the public view that is or is next to a park or a grounds of school or religious instruction, or that is or is next to any other public. Where was I here? Next, any other place where persons under the age of 18 can reasonably be expected to be present. A, for the first offense, a fine of $2,000, and B, for each subsection, subsequent offense, a fine of $4,000, or, go to my next page here, in any case, in any other case, A, of first offense, a fine of $1,000, and for each subsequent offense, a fine of $2,000, or B, an offense punishable on summary conviction and liable of imprisonment for terms no more than 18 months, and a minimum punishment of 1, in the case referred to in subparagraph A1. A, for the first offense, a fine of $1,000, and B, for the subsequent offense, a fine of $2,000. 2, in any other case, a first offense, a fine of $500, and B, for each subsequent offense, a fine of $1,000. So the thing I'm thinking about that is, or when I read that, I keep thinking about Justin Trudeau's, or even Princess's legislation on prostitution, where a woman can sell herself, but nobody can purchase, which is in itself like retarded, in my opinion, because it is, first of all, a violation of the Charter of Rights and Freedoms under discrimination to allow a woman to do something and a man not to do something. And then again, it's also kind of inhumane to tell a woman that she can go stand on the street corner when it's minus 50, but say, well, we're going to arrest anybody who tries to pick you up. That the whole thing is kind of not really thought through that well, and I don't really agree with it, and this kind of makes me think of that, and that whole thing needs to be repealed, so it's either both sides of it is legal or none of it is legal, because only allowing men to be able to do something or only allowing women to do something would still be gender discrimination under the Charter, in my opinion. And I know it doesn't quite say that, but when I read it the first time, that's kind of what I got, and I kind of wanted to share that with you anyway. There is one thing that I saw in the criminal code the first time that I read it, but I don't see it here again, and that's genital mutilation, because it was written in a way that only made it sound like you couldn't, it was only illegal to generally, excuse me, I'm looking for words here, generally mutilate, you couldn't generally mutilate a woman, but you could generally mutilate a man, which in my opinion, again, was sexual discrimination under the Charter, and I was thinking that should be changed, and male genitalia should be added to that, to give everybody a fair opportunity. But then again, we can always put in some information like with the respects to giving permission from a father, a rabbi, and a doctor. Maybe the Jewish community could still maybe circumcise their kids, but then again, maybe only in some those rare cases. And again, I think that's basically everything that I wanted to talk to you about the criminal code. From the most part, from what I read, it was a very solid document. You should definitely take a look at it, and I hope to hear from you about all your thoughts and opinions about what you've been reading. And again, I'm not trying to tell anybody this is how you do it. This is just what I'm reading and what I'm thinking, and I just wanted to start a conversation about, what do you think? Is it right? Is it wrong? Am I clueless? Let me hear something, or I would like to just hear your opinion, and thanks for listening, and stay frosty.